Good evening, everyone. Today we are starting our lecture on the topic of Unsound Mind, which is a defense available to you under Section 84 of IPC and Section 22 of BNS. Now, the reason why we are starting with this particular topic is that I have seen that in your papers, a lot of the questions are coming from the general exceptions chapter. So, in order to make it easy for you to deal with those particular concepts, we've thought of dealing with these sections as a priority. And if you go in for our course, then you will see that we have gone really in depth into each and every section. However, I'll try to give an overview in this particular lecture. So how I will go about this particular section is to tell you the history of the section, to tell you from which cases we drew upon the section, and then after which have there been any changes, have there been discussions, and have those changes been incorporated into the BNS, and has also the Supreme Court added to what is the meaning of the term unsound mind, also getting into important questions as to what is medical insanity, what is legal insanity, what is the meaning of the word insanity, and does it have a different meaning from the word unsound mind, right? So without wasting any time, we will go to our first discussion on when does the insanity plea actually come into picture. So the first time the insanity plea per se got notice was in the R versus Arnold case. Now in this case, this individual felt that Lord Oslo was going to do some harm to him, and therefore he himself committed harm to Lord Oslo. In this particular case, what was interesting is that the court said that this accused does not understand right from wrong, good from evil. Like, right, that's the term which is used here. They say that the visitation of God, a, if in the visitation of God a person is unable to decipher between good and evil, he cannot be guilty for the crime. So this is the first time in some concreteness the court deals with this particular concept of insanity and says that if a person is not understanding good and bad, then they should be given some kind of concession, they should be given some kind of protection from the law. And so the first time that we feel with some stability, some importance, this plea was introduced was in R versus Arnold. Now, this was also known as the wild beast test. So, one credible establishment of the insanity plea or discussion on the insanity plea starts with R versus Arnold. Then we go on to the Hatfield case. Again, you see that this person, Hatfield, he tries to assassinate King George III, and he is again under a delusion in his mind that he's going to suffer some harm at the cost of King George. And therefore, the court says that because he's under a delusion, he's not proper in his mind, we must protect him. And from there came the insane delusion test. But now, what has to be remembered, they had some requirements even in this test. They saw that this person, Hatfield's insanity or delusion, was of a permanent nature, and that really contributed for their decision. It played a role in their decision, and they felt that it constituted insanity or the insanity plea for them. Right. So, first one, R versus Arnold, again, a person under a delusion. And the court says he's not able to understand right from wrong and therefore gives him some concession. Second case, again, we see Hatfield's case, and there also there is some delusion in the mind of Hatfield because of which he harms or tries to assassinate King George III. The court again gives a protection, says that if a person is under a delusion, they can be protected. Going further, we now come to this case. Without much wasting much time, we come to the most important case in section for section 84, on which section 84 is based, which is the Emnathens rules or the Emnathens case. Now, it's been spelled in different ways. Amnathins, McNaughton's is also the term that is used. But the case is that this man, Amnathin, he tries to assassinate the Prime Minister, Sir Robert Peel. And when he goes to assassinate Sir Robert Peel, instead he ends up killing Sir Edmund Drummond, who is the private secretary of Robert Peel. Now, what happens is when this case comes to court, it is established that Amnathin was under a delusion again that Robert Peel is going to, harm him, and therefore he tried to harm Sir Robert Peel. So, in his mind, it was basically an act of self-defense. He was trying to protect himself because he felt Robert Peel was going to commit an act on him. And again, we see that the court let him go. The court did not find him guilty of the act, and they again said that the ground was of insanity. Now, what happened is because Robert Peel was the prime minister and he had tried to kill the prime minister, and already one person by mistake had died, which was Edward Drummond. There was a lot of sensation around this case. There was a lot of criticism that he was allowed to be, he was released without facing any penalty. So, what happened is that the House of Lords requested that a 15-judge bench comes in and they give some kind of clarity on what is insanity, what is the plea of insanity. After which, five major rules were introduced by the court. And those were, the first one being that a person is presumed to be sane. When you are an accused and you are charged with an offense, you are presumed to be sane. If you say that you have been of unsound mind or insane at the time of the offense, then the burden of proof is on you to prove that you were insane, right? The court will presume that you are sane, right? Next, the second rule that was introduced is that the person who's taking the insanity plea must not be aware of what they are doing, and they must not be able to understand what they are doing is contrary to law, or that what they are doing in those English terms is that they should ought not do, meaning they should not be doing that action, it is illegal. This they must not be able to understand. You must be so insane that you are not able to understand that the action that you are doing is contrary to law or is something that you ought not do. So this is the second rule that is introduced. The third one is that if such person is under a delusion in his mind, that delusion can be considered real, and responsibility would be levied on the basis of this delusion. Now, as we discuss what is happening in India, we will discuss how much of this third rule is followed in India. As of now, first one very nicely followed in India, second one followed in India, third is also followed, but there are some rules to the following of this third aspect. Fourth one, to establish the ground of insanity, it must be clear that the person is insane at the time of committing the offense. The person must be of unsound mind or insane at the time of commission of the offense. This also has been accepted by our legislations, through our rules that we follow in India also. Now, coming to the fifth one simply states that if a medical individual is involved, he cannot be made a witness to this particular type of case if he doesn't know the person before the trial. So let's read this out. A medical man conversant with the disease of insanity who never saw the prisoner previously to the trial but was present during the trial cannot be asked to give his opinion. So a person who does not know him previous to the trial is not allowed to give the medical opinion, right? So five important rules introduced. We see that the first one, which is a presumption of sanity, very much followed in India. We see the second one, which is that if you don't understand what you're doing is wrong, or that is contrary to law is also incorporated in India. When we discuss, you will see that. But the third one, whether delusions, or if a person is under a delusion, whether that delusion is accepted as reality, is a discussion we will get into. And then we also see that there is something in relation to medical. A person who is if he's a medical officer, he cannot be a part of the trial if he didn't know the person before the trial. And lastly, the insanity or the mental illness must be there at the time of commission of the offense, right? So these are the 5 things that were introduced. This is your main case for section 84. This became the backbone of section 84. In your exams, in especially the prelims, the MCQs, it is one of the most common questions that is asked in your papers. I have provided only one, but is repeatedly asked in your papers in different forms. The Nathan rules generally comes in the preliminary paper. Right? Now, after the insanity plea, it's not when it was introduced under the Nathan's rules, it's not that evolution of this plea didn't happen. It did. So the next new or the conversation also led to a discussion on the principle of irresistible impulse. Now, what does this simply mean? It means that a person is afflicted by a disease, and that disease has led to an impulse. It has led to them doing something which they have now no control over. And the justification of this principle is that if you have no control over, and if you are doing an act without a will, without the will to do it, then in that situation it is not your own action. It is beyond your control, and therefore you should receive some protection in this particular case, is what this principle says. Now we see that in England, to some extent, this was accepted. It was in fact considered an additional rule to the Nathan's rules, which could have been accepted, but it is not very largely accepted as a concept. I will also discuss with you how it is dealt with under the Indian laws. Now, these are some of the High Court cases which I saw, where the court said that irresistible impulse in itself is not enough, or just a lack of motive is not enough. What does this mean? That, for example, let us say A kills B. Now, when this A has killed B, he had no motive. There's no reason. Just because he has no motive, it doesn't mean that we can go up with the plea of irresistible impulse. The courts say that for irresistible impulse, there must be a lack of control, a complete lack of control, plus a mental illness. So, together with a mental illness or disease, lack of complete control, does the plea of irresistible impulse come. Most people were misusing this particular plea and saying that because there is no motive, it is irresistible impulse. The court said no, it is not irresistible impulse. You need something more than that. You need some kind of complete absence of or lack of control on your part, which is stemmed towards the disease that is there in your mind. For example, if you've heard of Ted Bundy, he's a famous serial killer. You can, if you Google him, it's a very interesting read. Now, Ted Bundy at one point was jailed, and he escaped jail. Now, when he escaped jail, he on one occasion entered a hostel. He tried to be sexually intimate with one girl who was sleeping at night in the hostel. He failed, after which he simply took a hammer and he started hitting on multiple girls in the room and killed them. Now, there is no reason, there is no motive, there is no logic, but he just could not control himself. He had to enter, he has left a jail. Now, a person logically, if he's escaping jail, will try to hide. But no, this guy goes and enters in the night into a female hostel, and then first tries to be intimate with a woman, fails, and then kills a multiple number of girls. In my mind, this could be a case of irresistible impulse, wherein you have no more any control over what you are doing, and therefore, for that reason, it's just not possible to say ki he is a normal person. The disease is so much that it has contributed to this crime. He cannot control himself. He has no volition towards the act. So, what is irresistible impulse? It is where there is a disease of the mind and there is lack of control. That is irresistible impulse. Now, this person may understand what he's doing but cannot control what he's doing because of his illness. That is the irresistible impulse plea. But in India, irresistible impulse plea requires not only the disease, it does not only require the lack of control, it requires for you to not understand right and wrong. You are so uncontrolled that you have no understanding of right and wrong, or you have no understanding of what is illegal, right? So we see that somewhere the Nathan's principles have been incorporated here again in India. So India does and consistently keeps going back to the Nathan principle, especially when it comes to lack of understanding of what is right and wrong and what is contrary to law, right? So repeating myself, irresistible impulse, what is it? It simply means that a person has a disease of the mind, and that included with an irresistible impulse. Even if you have understanding of what you're doing, if you have a irresistible impulse, and if you have a disease of the mind, you will be given the protection of the insanity plea generally. But in India, you are additionally expected to not understand what you're doing, to not know that the act is contrary to law. We will go further into this discussion. For now, simply remember that there is this concept of irresistible impulse also, apart from the Nathan's rules, which has been discussed previously, which has been on an international level been incorporated into the insanity pleas in some cases, right? Now, moving further, another rule also happened in the 1954. It was not introduced per se in 1954. It had been discussed earlier, but in 1954, in the case of Durham versus United States, it was reintroduced, and a comment was made that the Nathan's principle was not sufficient, because we must understand that this is 1954, when psychiatry, psychology, everything has progressed, and the case of Nathan is from 1843. So almost 100 years have passed since that case, and now the courts are saying that the principle should evolve. So now, what does the Durham rule say? The Durham rules firstly did one thing. It said that if there is a causal relationship between crime and disease, then there must be some kind of exemption given to the person. Whatever mental illness you have, if that particular mental affliction has led to the crime and you can prove that this has led to the crime, then you must be given some kind of relaxation in criminal liability. Now, let's just simply, for an example, if we take that a person is an alcoholic. Now, alcoholism is an illness. Now, if that illness makes you just push through and take some kind of drinks, and that causes some harm to the front person, the belief is that the disease has led to the crime. Because in this discussion also, we see that there is some conversation on control. The disease is so strong that your impulse cannot be controlled to commit some form of crime. So it was a more modern take on the insanity plea. Another important thing the Durham rule stated was that psychiatrists and psychologists would play an important role. There should be diagnosis of the disease, and apart from that, if we are able to establish this relationship, then there should be some relaxation which is given to a person who is taking this particular plea. So this is an important transition. Up till now, we don't see a lot of importance being given to psychiatrists or psychologists, but the Durham rule did feel that there should be some importance given to medical professionals. Up till now, you must have never heard me saying that. Neither in Emnathan's rules, neither in Irresistible Impulse, neither when I was discussing the previous cases did I ever mention medical professionals. But Durham rule is the first one where very clearly they want to give some importance to people from the scientific field who are experts on mental illness. So they wanted to give some kind of credibility to psychiatrists. So again, repeating myself, what is the Durham rule? If you can prove there is a relationship between the crime committed and the mental illness, there should be some relief given to a person who is involved in such type of a crime, right? So again, speaking about people who are going through crimes like Ted Bundy, who was into sexual crimes and also acts of necrophilia, etc. In those cases, it was felt that he suffered from a particular form of illness which basically led to him committing these type of crimes. So there was a relationship there, but unfortunately even in his case, not much importance was given to any kind of medical history or medical analysis of him, right? It was simply limited to the law. Now, this is another important introduction that happens in 1962. The Model Penal Code is introduced in the USA, which is a combination of Emnathan's rule of the irresistible impulse test, etc. Now, what does this code do? It says very generally that it requires medical professionals to make a diagnosis if a person is mentally ill, diagnose them with that illness. It also says that Emnathan's rules, where we discuss this point of where a person is not able to understand what he's doing is wrong or that is contrary to law, those concepts have to be taken into consideration. But while in this particular case, in this model penal code, the test says that they must not be able to appreciate what is wrong or contrary to law. What does this mean? That if a person is unwell mentally, they must be in that illness should be to such an extent where they know what they are doing is wrong, but they are not able to appreciate. So it's something more than knowledge. Knowledge is lesser than appreciation. Okay, you are not able to while you know the act, you are not able to understand its magnanimity in totality what you're doing. So going back to Ted Bundy's example, he knows it's wrong, he knows using a hammer on somebody's head is wrong, but he's not able to appreciate, he's not able to in some ways assess what he's doing, right? So knowing and appreciating are two different things. So the court said if you're not able to, you may know but you are not able to appreciate the action, then you are protected under the Model Penal Code test. You will be considered insane under the Model Penal Code test, and therefore criminal liability may be reduced on you, or you may be even exempted from criminal liability if you come within the test. Now, this test is still followed in predominantly most parts of the US, not all of it, but most parts of the US. Now, after this discussion, what we understand is in 1843 we had Nathan's rule. Considering that it was in 1843, in 1860 it was quite an updated legislation. But then what happens by the time we come to Bharatiya Nyaya Sanhita? We have seen Durham rule happened, we have seen model penal code happened, we have also seen a discussion on irresistible impulse and so on and so forth. Has there been a change in Bharatiya Nyaya Sanhita after so many things happening in the middle? There was also a case of Joseph versus Atkins, if you want to read. All these cases are there, and still what we see is the Bharatiya Nyaya Sanhita only regards the Nathan rule, which means that Indian Penal Code and Bharatiya Nyaya Sanhita still use the same definition for the insanity plea. So, up till here, I have tried to give you a history of the insanity plea. I have told you that the Nathan's rule is the backbone of the insanity plea in India, and I have also tried to explain to you, even though there are many changes that have happened, India continues to be working on the basis of the old Nathan's rule, whether it was in the IPC or even today now in the Bharatiya Nyaya Sanhita. All right. So now we come to our actual legislation. This legislation or this section has not changed whether it is under IPC or whether it is under BNS. We see that the section starts as nothing is an offense which is done by a person who at the time of doing it, this is a principle from M. Nathan's, if you remember, one of the principles of M. Nathan's case, by reason of unsoundness of mind. This is the term they are using, unsoundness of mind, not insanity, not mental illness. The term remains unsoundness of mind, is incapable of knowing the nature of the act. Again, this is something which is incorporated from M. Nathan's rules, doesn't know the nature of the act, or that he is doing is either wrong or contrary to law. Now, these are aspects which we saw under M. Nathan's rule. Now, they were very generally stated in the M. Nathan's case or after the M. Nathan's case when the rules were established, but here the placement is relevant. The terms are relevant. The word used, unsound mind. And then it says, is incapable of knowing. Such person is unable to know. If you remember, I just told you the model penal code uses the word appreciate, but we use the word knowing. Now, why is this important? I will tell you. So, such person is incapable of knowing because of unsoundness of mind, the nature of the act, or after all, that what he is doing is either wrong or contrary to law. So such person is of unsound mind, but such person or being of unsound mind should not know what he is doing either is wrong or is contrary to law or does not understand the nature of the act. So the question comes in is, what are the essentials of this particular section? Simple. Person must be of unsound mind. Unsound mind, what is the meaning of this term? We get from this. This is what unsound mind is. Right? Now, such person must be incapable of knowing the nature of the act. As I said further, what do you mean by nature? What is what he's doing? He's unable to understand. He's cutting somebody's head. What is that act that is going to kill the person? He is unable to understand the action that he's doing and the repercussion that it is happening. So the nature of the action could simply mean where A says he starts using a knife on B and is not understanding what it's doing to him. He's not understanding the nature of his action. Now, what is contrary to law? Meaning illegal, that it is not allowed under the law. So the person must not understand that what he is doing is an act which is illegal. He must be so insane that he must not be understanding that the act is illegal. Next one, the act was wrong. Now, what do you mean by wrong? Wrong simply means that in a societal sense, do you feel that this action is wrong? If you do not understand that it is wrong, if you do not understand that this is contrary to law, or if you don't understand the nature of your action, you are so medically insane or of unsound mind, then in such case, the protection of Section 84 is available to you. But this unsoundness of mind should be present at the time of commission of the offense. If you are unsound mind before the offense or after the offense, irrelevant. To some extent may be relevant, but for this offense, it has to be proven that at that particular moment you were so unsound that that insanity led to you not understanding either nature or that the action is wrong or contrary to law. At that moment, there must be the unsoundness that is mentioned here. Now, while we deal with this part of the section, it is important to also remember that you get questions in your prelims and in the mains about what is the term used in section 84 to depict insanity. The word is unsound mind. Another question that is asked to you in your mains is, what is the difference between the word unsound mind and insanity? Technically, there is no difference. There is an interchangeability in the words. You will see that when we deal with cases also, the court has said that these words are used interchangeably. In fact, we very often say insanity plea, right? But unsound mind or insanity, these both words, if used in the context of 84, must mean these things, which is what? That such person does not know either nature of the act or contrary to law, or that it is wrong. And this incapacity of the person must be present at the time of commission of the offense, right? So whether the word unsound mind or insanity, firstly, they are used interchangeably, but the definition of unsound mind is the fulfillment of these ingredients. Okay. Now, what is medical insanity and what is legal insanity? For your benefit, I have provided this definition because it very clearly, for your reference, defines the difference. Medical insanity and legal insanity can be differentiated simply by saying that medical insanity is a big umbrella. It's a big umbrella, right? Many people have many illnesses, and a doctor, a psychiatrist may say, for so and so reasons, you are medically insane. Now, you may be medically insane, but if you understand either nature, if you understand that your action is wrong, is contrary to law, in the eyes of law, you are not legally insane. Is clear, the law is clear. If you are wanting to declare a person insane for the purpose of IPC, insanity means fulfillment of these ingredients. You may be medically insane, but if you don't fulfill these insane, you are considered a normal person for the purpose of offenses under IPC. For that purpose, for the defense, for the general exceptions to be applicable to you, you have to prove that the ingredients provided here are complied with by you. So you have to prove either you don't understand nature or you don't understand that it is contrary to law or wrong. Do you understand this? That medical insanity, very large spectrum. There can be many people in many occasions who are considered medically insane, but legally, because they don't fulfill these ingredients, because they understand nature or they understand that the act is contrary to law, they don't come under the ambit of 84 and they are considered legally sane. So legal insanity is the fulfillment of section 84. Medical insanity is where you go to a doctor, doctor will assess you, and there can be many varied reasons for which you can be declared as medically insane. So reading, just giving a quick reading to this definition because it brings clarity. The distinction between legal insanity and medical insanity is that despite the insanity which doctor may find in a particular person, that person is able to recognize the nature and quality of the act for which he is tried, or if he is capable of knowing that what he was doing was either wrong or was contrary to law, then the benefit of section 84 would not be available to him. If you understand nature, if you understand that your act is wrong or contrary to law, you may be medically insane, but legally you are sane. Legally, a person can only be considered insane if he fulfills the requirements of section 84, which is that the person should be incapable of knowing either nature or should not be able to understand that the act is contrary to law or was wrong. All right. So we have understood medical insanity and legal insanity. Please be cautious about this because this comes in the paper as a question. Now coming to burden of proof. When we discuss general exceptions, section 105 of Indian Evidence Act is primarily brought into play, wherein if you're taking a defense or if you're using an exception, then you are the person who has to prove it, right? But now in the case of insanity, of course, as we said, as we discussed in the Nathan's case, the presumption is that you are a sane individual. So if you are using this particular defense of unsound mind, then in that situation, to what extent are we to prove insanity or unsound mind is the question that comes in. 105 says that if you use an exception, you have to prove it yourself. But to what extent can we prove insanity is the question we will slowly try to now answer with the help of case laws. Okay. Now coming to this case of Shrikant Anandrao Bhosale versus State of Maharashtra. What is the case basically about? The case is about this man A and his wife B. Now A and B have a quarrel. B goes to wash clothes. A goes with a grinding stone and hits her and kills her. After killing her, he stays there itself. Right. Now, he's first thing, post incident, he's still sitting there. They had a small quarrel regarding something which was basically very minor, not very big. He hits her with a grinding stone, kills her. After the act sits there, before now the act, let us go into his history. This person did have some kind of psychiatric issues. He was going to the doctor, he was taking treatment, he has been visiting the doctor multiple times for psychiatric issues, and also had a parent who had some kind of psychiatric issues. So has a history of psychiatric problems. has a parent who had psychiatric issues, has a minor fight, uses a grinding stone on the wife, kills her, and then stays there itself. Insanity plea was brought up by the defense, saying that he is of unsound mind. Right? Now, question comes in is how do you establish at that time was he insane? Afterwards, he's sitting right there. This is weird. After committing something so harsh, you are still sitting there. Is an abnormal act. Yes. Before, yes, you have gone to the doctors and you have visited the psychiatrist, etc. In this case, it has been proven that he did. But now, how do you prove at that time is he of unsound mind? So, for this discussion, we will just discuss that particular case. Just give me a moment. I will open the case law. So now if you see, this is the case of Mr. Bhosale, wherein he tries to have a conversation which results into a fight with his wife. And in that particular fight, we see that it goes into a way where he takes a grinding stone and he kills her. Before the action, we know what has happened. After the action, what we know what has happened. Now, the court referring to this case. Now, this case is a landmark case, and this case is what is relevant for you when you refer to burden of proof, which is Dyabhai Lal Thakkar versus State of Gujarat. In this particular case, the court gave three important things which must be remembered in case of the burden of proof in the context of the insanity plea. First thing it says that the prosecution must prove beyond reasonable doubt that the accused had committed the offense with the requisite mens rea. And the burden of proving that always rests on the prosecution from the beginning to the end. So the burden of the prosecution to prove beyond reasonably doubt that the accused caused the action is always maintained. That is always there. The second thing is there is a rebuttal presumption that the accused was not insane when he committed the crime. In the sense laid down by Section 84 of IPC, the accused may are, but it by placing before the court all relevant evidence, oral, documentary, or circumstantial, but the burden of proof upon him is no higher than the rest of the party to civil proceedings. The court declares that burden of proof is as much as in the civil proceedings. The accused must put forward all the material available to prove the fact that he is insane. And the last one, the last position that they introduce is most important. Even if the accused was not able to establish conclusively that he was insane at the time he committed the offense, the evidence placed before the court by the accused or by the prosecution may raise a reasonable doubt in the mind of the court as regards one or more of the ingredients of the offense, including mens rea of the accused. And in that case, the court would be entitled to acquit the accused on the ground that the general burden of proof resting on the prosecution was not discharged. So, what it in short meant was that the purpose of the accused providing the insanity plea will be more or less fulfilled if he creates a reasonable doubt in the mind of the court that yes, there is insanity. There are some aspects of insanity which are there in the case. So, this particular case very important because you have had a question on what is the doctrine of burden of proof. Doctrine of burden of proof introduced here, but we'll get into a further discussion here. Look at this. The court in the case talks about the circumstances of the case. It talks about the family history. It talks about the ailment which is maybe hereditary. that the appellant was being treated for unsound mind and was diagnosed with paranoid schizophrenia. Within a short span, which is between June to December, he had been taken 25 times to the hospital. There was very weak motive to kill the wife, and he was killing in daylight, and he made no attempt to run away. So, what do you understand? Why is the court enlisting these seven circumstances? Simply because the court felt that there is enough to create reasonable doubt in our mind that this person may be insane, right? And therefore, maybe the situation is such that section 84 can be applied to this particular case. So what was laid down in the Thakkar case, that is, if there is creation of reasonable doubt on the basis of things submitted, on the circumstances provided, then that can be sufficient to provide either exemption or reduction of criminal liability to such an individual. So the court highlighted that here. So I have again highlighted where the court says there is reasonable doubt that at the time of commission of the crime, the appellant was incapable of knowing the nature of the act by reason of unsoundness of mind, and thus he is entitled to the benefit of section 84. Hence, the conviction and sentence of the appellant cannot be sustained, and this person was allowed to leave, or he was exempted from liability for this particular case. I hope that I have made some sense here. I will just reshare my screen. Just give me a moment. All right. So we have looked at this case. As we deal with this case, I also want to mention that persons of unsound mind have been declared to be of four types. One is an idiot, that is an individual who is considered not of sound mind from birth, right? A lunatic who is in phases unwell, right? In certain phases, he is unwell. So, in the phase when he is unwell, if he commits a crime, he can be given the protection of 84, right? These are people who are unwell in intervals. Next is non-compos mentis. It basically means that through an illness, you have become insane. You have lost your sanity. Next is delirium tremens, or this is through drunkenness where you have incorporated or some kind of level of insanity has come to you. So when you are trying to withdraw from alcohol, also there is some kind of insanity or some kind of unsoundness that comes to an individual. They have been acknowledged under the law. Now coming to the case of Raman Raghav. Now, why I'm discussing this particular case is also because you must have watched the movie which was by I think Nawazuddin Siddiqui about if of Raman Raghav. An interesting movie also, and the case is equally interesting because this case again discusses the meaning of the term legal insanity and medical insanity. Just for our brief understanding, I am repeating this particular part, even though we have discussed this in the past, just a good explanation of the term legal and medical insanity. If, despite the insanity, the doctor finds a particular person to recognize the nature and quality of the act which he's tried or is capable of knowing, that what he was doing was either wrong or contrary to law, benefit of section 84 is not available to him, right? So medical insanity and legal insanity discussed in the case. Now, what was the case? Raman Raghav was considered to be a serial killer who killed almost more than 40 people. He had multiple trials happening on him, right? And in one of these trials, one of those trials, he was given the death penalty. And that particular case came again to the High Court, and it came for the question of can he be given the insanity plea? Can he be given the defense of insanity? Even in the trial court, it was brought forth, but it was not accepted. Let us discuss what happens here. Now, this is a very interesting case in the context of how the court dealt with this person, Raman Raghav, who killed almost 40 people on the road. And he, in his confession, stated that when he was asked why he did it, he said that he was being ordered by something called as a Kanoon. Kanoon is a Hindi word which means law, right? He was being ordered by a law to commit those crimes. And as we go through this case, you will even see his justifications as to why he committed these particular murders. Now, because he started saying these words, a medical board was set up, and the medical board assessed him. Another individual known as Dr. Patkar, who was also a specialist in the field of psychiatry, assessed him. And he continued to make the same statement, the statement that there was a Kanoon which was telling him to commit all the murders. Right. Now, I have highlighted an extract from this particular incident which the board where the board had interviewed him. So you see the first thing that they have mentioned, Sindhi Dalwai, which is Raman Raghav, is of unsound mind. They declare him of unsound mind. He is suffering from psychosis called paranoid schizophrenia. He is dangerous to society and is certifiably insane. Medically, they are considering him insane. Second statement, Sindhi knew the nature of the act. That is, he knew that he was killing human beings. He knew that he was killing individuals. Thirdly, he did know that what he did was wrong and contrary to law of the land. But he firmly believed that what he was doing was right and in tune with the law of Kanun, whose law, according to him, was obligatory for him to follow. So these are very paradoxical statements. First statement, they declare him medically insane, certifiably insane. In fact, they are clearly trying to say that this person is not normal. And they say the word unsound mind also, right? Second thing, but they say he understands nature. Third thing, they say he understands it is wrong. He knows that the act is contrary to law. And as I told you, you may be medically insane, but legally the requirement is that you must not know the nature of the act, or you must not know that it is wrong or contrary to law. Here, Raman Raghav knew all these things. He knew the nature of his action. He knew his act was wrong and he knew it was contrary to law. But still, the court, but still, the doctors continued to say that he was certifiably insane. The court is now at a crossroads where medically an individual is insane, but he knows nature, he knows the act is wrong, and he knows that it is contrary to law. So technically, as we all know, that the court restricts itself to only whether a person knows the nature of the act or whether the act is wrong or contrary to law, right? But the second half of the third point is interesting. It states that he firmly believed that what he was doing was right and in tune with the law of Kanun, whose law, according to him, was obligatory for him to follow. So now there is a problem. What is the problem? Raman Raghav knows nature of his action. He knows it is contrary to law, but he believes he is right. He doesn't believe it's wrong. So this is interesting. He actually believes what he's doing is right, and he's so delusional. If you see, I have highlighted it further also. He has an unshakable delusion that he has to follow the Kanun, and therefore, because he has to follow the Kanun, he's doing an action which he feels in his mind is right. So, why, and this is precisely why I had highlighted and introduced this case. The court says merely because a person hears a command from above maybe from the sky or in his dream, or obeys the command of a person like the Pir in Gero Ali's case, some imaginary prophet, and then in pursuance of that command proceeds to murder people, he cannot be allowed to say that though he knew the nature of the act and that he knew that he was doing was contrary to law, he did not know that it was wrong, and therefore he should be excused in view of the provisions contained in Section 84 of the IPC. Any interpretation of Section 84 which would uphold such claims would spell catastrophe to the society, especially a society like our country. It is established beyond reasonable doubt that the accused went to the place of offense after making preparations for meeting a situation where he could use the weapons which he was carrying. He knew the nature of the act, that he was killing two people. He knew that he was acting contrary to law because, fearing apprehension, he ran away. He knew that what he was doing was contrary to law, also because he hid the weapon of offense in a place fairly removed. So, two things which the court is saying, which is very interesting, even though in some way they are accepting that he does not believe what he's doing is wrong, but they say that in society we cannot accept this justification, we cannot use this defense to provide the insanity plea. So, it's an interesting conversation where the court has no answer to the question, where somebody, where the defense is able to establish that he was not understanding his action to be wrong, and yet they still didn't give him the protection of the insanity plea. This could be a loophole that had come in. The court further states that because he hid his weapons, he ran away, because he knew the kind of weapons he was carrying would cause serious harm, he understood nature of the action, he understood that it was contrary to law, and therefore in their minds that sufficiently would lead to the discussion that Section 84 should not be provided to him. In this para, I have just highlighted how the court tries to say that we must give importance to psychiatrists and psychologists when they give their opinion. Of course, the final decision which should be with the court, but psychiatrists and psychologists must play a more important role in diagnosing such people. So the court accepts that that is one perspective which should be looked into, right? And lastly, we see that in this particular case, Raman Raghav is not given the insanity plea, even though even though he has medical insanity on his favor, because he understood nature, because it was uh, something he knew was contrary to law. Even though there was a debate whether he understood it was wrong, the court still felt that he could not be considered legally insane. Medically, maybe he is, but legally, he is not insane because he understood nature and he understood that the act is contrary to law. Again, I wanted to highlight how deluded Raman Raghav was. He was asked, "Why did you kill the two persons at so and so place?" He said, "I killed them because there was a war between the three governments, the British government, the English government, and the third. I also killed them for greed and money. I cannot give more details about war." So the war he's talking about basically was not there, because this is post-independent India, right? This is the 1960s. In 1960s, there was no British government, there was no English government in India. So which war is Raman Raghav talking about, right? So he was completely under a delusion. And therefore, if you remember, I had discussed with you the fourth point of the McNaughton's rules, where it was stated that if a person is under a delusion, that delusion should be considered real. But we see that the court does not give much relevance to the delusion part of it, but gives a lot of importance to the fact that does the person understand nature of the action, or that it is wrong or it is contrary to law. This last para of the case I have highlighted mainly because to show you that the court does not change the decision of the lower court. It continues to say that he does not get the benefit of the insanity plea, but it states that because for 18 years he has lived under the death penalty punishment which was given to him, it will be commuted to imprisonment for life. It will be reduced to imprisonment for life, but the insanity plea will still not be available to Raman Raghav. So the reason for sharing this case with you was simply to try to elaborate on the fact that there can be situations where the person is medically insane. In fact, even the board has provided it in their report that they find he's completely of unsound mind. That is the word that they are using. But still, they are not given the protection under Section 84 because they are not considered to be legally insane. They are considered to be medically insane, but Raman Raghav was not considered to be legally insane. Another case that we were to discuss was S.K. Nair versus State of Punjab. This case, basically, there are a multiple number of people who are in the forces. Now, one person enters this place where multiple people are sleeping and sees that she is sitting up with a kukri, that is a dagger in his hand, right? And this man then attacks A on seeing A. B gets up and tries to help and says that because they were all working in the forces, B says, I will inform the police officers or our superiors what you are doing. And C responds that you will only be able to inform them if you are alive. And then goes on to kill these people. He kills the B. Right. Now, after the incident, C says that I was under psychosis, I was under paranoia, and therefore I should get the insanity plea. I should get a protection of Section 84. The court said that if, especially seeing the statement that you gave, that if you were still alive, only then can you go and report to your superiors. It means you understood what you were doing, you understood the nature of the act, you understood it's wrong and contrary to law. So you had complete understanding of the action. Even if you are a person who suffers from paranoia, at that time you were lucid, meaning you were having full senses of what you were doing. And even if this was for a short interval, at that time you were a normal person when you committed the act. And we know in Section 84, you must be of unsound mind at the time of commission of that action. But here we see that at that particular time you are lucid, you are quite normal, and therefore the insanity plea is not available to you, right? He was not given the benefit of Section 84. This is another MCQ, which is simple MCQ, which is asked to you. Section 84 of IPC deals with the act of a person who has madness, mental ailment, unsoundness of mind, or insanity plea. We know that the term used in 84 is unsoundness of mind. Go to this case. This case is very important. It is the latest case law. So it happened last year, and it has extended, or it has given a comment on the burden of proof which is there on an accused if they take the plea of insanity in India, right? So an important case. And just to give you a heads up, if you see that this is a descriptive question that has come in your papers, which primarily speaks about this doctrine of burden of proof. So very rarely asked, but when asked, the doctrine of burden of proof is asked. So this particular case law is a very comprehensive case law. If you read this case law, a lot of the landmark decisions which are required are already there. The landmark principles are already there. So one case law will help you deal with that particular question. This is one of the main reasons why we must look into Prakash N versus State of War. So what happened in the case, I'll give you a brief of the facts, is that this man A is working in a shop. Now, early in the morning, somebody comes to the shop or is close by to the shop. A, with no reason, goes and hits him with some kind of not a weapon, but there was like a lock plate which was there, it is mentioned, and he uses that to hit him. Now, this person was not behaving very normally prior to the action also, and therefore a plea of insanity was introduced in the case. So I'll just share the case and we can have a discussion on what really happened in the case. Okay. So if you get a chance, you can always read this highlighted quote which is there in this case. It's very rare that judges start with with literature. So Judge Sunderesh has quoted Shakespeare in this particular case very nicely. Again, they have again spoken about medical insanity and unsoundness of mind. So medical insanity cannot mean unsound mind. There may be a person suffering from medical insanity who would have committed an act. However, the test is one of legal insanity. What this means is unsound mind is equal to legal insanity. Medical insanity is separate. Unsound mind is equal to legal insanity, which means the requirements of Section 84 have to be fulfilled. The person must be of unsound mind, and such person of unsound mind should be unable to understand the nature of the act, or that it is contrary to law or wrong, right? And this must be present at the time of commission of the offense. So unsound mind is related to legal insanity present in Section 84. Medical insanity, a larger umbrella, and which denotes a person who may be having a varied form of medical mental issues, right? Now, coming back to this case, as I said, that the court was at this point of understanding how much must be proved when a person is taking the insanity plea. And this paragraph 8 is of a lot of relevance. As I have already told you, general exceptions, the burden of proof is on the person who's taking the exception. That is already there under 105. But in paragraph 8, the court elaborates on how far of burden of proof must be there on the part of an accused who is wanting the insanity plea. So the court says that the burden of proof does lie on the accused to prove to the satisfaction of the court that one is insane while doing the act prohibited by law. Such a burden gets discharged based on a prima facie case and reasonable materials produced on his behalf. The extent of probability is one of preponderance. This is for the reason that a person of unsound mind is not expected to prove his insanity beyond a reasonable doubt. Secondly, it is the collective responsibility of the person concerned, the court, and the prosecution to decipher the proof qua insanity by not treating it as adversarial. So, this is an important addition that the court made. The court said that the accused has to create reasonable doubt, and that has to be of preponderance of probability, which means that the situation is such that in all probability the person who committed the act was insane. It doesn't prove completely, but it creates the probability that most probably this particular person was insane at the time of the commission of the offense. The important line added is that it is the collective responsibility of such person, the court, and prosecution to decipher the proof of insanity by not treating it as adversarial. So this is where the court is saying you must come together to prove insanity. The adversarial nature of court means what? That where it is X versus Y. So you must move away from this adversarial mindset and come together to try to understand whether the person has insanity or has the is capable of taking the plea of insanity. But before that, they said ki, of course, the accused has to prove that there is reasonable doubt. He has to prove by all preponderance of probability that there is a case of mental illness and insanity plea involved, right, of unsound mind. After which, if this is there, then the court, the accused, and the prosecution must work together to find out proof for insanity, and it should move away from the adversarial mindset, right? Last line is also important. The person is presumed to be sane once there are adequate materials available before the court. The presumption gets discharged. So the presumption is removed of sanity once adequate materials are brought before the court. We again see Daya Bhai, Chagal Bhai Thakkar. The Thakkar case is referred to again. The court again says that mere abnormality is not enough. It is citing cases and stating mere abnormality is not enough. You have to properly prove that there is reasonable doubt, right? Again, the court has re-elaborated on the fact that reasonable doubt should be proved. Once reasonable doubt and preponderance of probabilities are there, then in that case, the court, the prosecution, and the accused must come together. In this part, I just wanted to highlight, even in this case, this man, he was being treated for neurosis. He has been treated for anxiety and reactive depression. And apart from that, peptic disease, etc., and so on and so forth. So he was having a history of some kind of illness. There was some kind of evidence from doctors taken wherein they felt that he had schizophrenia for at least 16 years or more, and therefore the court said with the amount of material that is available, it is clear that this person was of unsound mind when he committed the offense. In fact, the court said that he has now become better. He has healed himself, so he can be brought back to even society, right? So if you see, the last line states that he stood discharged. So the court discharged this man and allowed him to get back to society. So the point of this case mainly, apart from the Thakkar case, it introduces in para 8 an additional point, which is the preponderance of possibilities, and adds to it also the idea that adversarial system should not be followed in such cases. In fact, that there must be a collective responsibility of the court, the prosecution, and the accused in such cases. Okay. So with this, we have understood this particular case. Yeah, so important takeaways from the case. Basically, that the burden of proof is on the accused to some extent, which is that extent reasonable doubt, preponderance of possibility, and then after which it should be collective responsibility of all the three parties that were mentioned, right? And in such cases, then the benefit of the insanity plea could be given and such person could be discharged. So now there is one more line that I have written here, that in some scenarios, the court felt that the trial court and the high court, what they do is they only look at the nature of the act. They only look at the fact that the person has committed murder and he's committed a very harsh act, and stop understanding the fact that the accused is also having proof of the fact that there is some kind of mental illness that he is suffering from. So in fact, even in this case, the court pointed this out, that it felt that they ignored the doctor's, evidence which was given, where she states that he did suffer from mental illness, etc. So the court is also trying to identify flaws in its system itself. It was just a point which I felt could add to, this discussion. And coming back to our last question for the day, which has come in your papers and which I felt is something we easily ignore when we deal with the insanity plea. So the question is, the law presumes that every person committing a crime is sane and liable for his acts. Section 84 of the IPC carves out an exception. Elaborate on the doctrine of burden of proof in the context of plea of insanity. Now you know collectively that yes, there is the presumption of sanity which was brought through M. Nathan's rule, and the 105 section of Evidence Act also states that it is the person who takes the exception or the protection of the exception who has to prove that they can use it. But then we transcend towards this doctrine, which was established in the Thakkar case, where three important principles were introduced. And subsequently, even today in 2023, we see that the court is adding to it, talking about concepts like preponderance of possibilities, talking about re-establishing reasonable doubt, and talking about how the court, the prosecution, and the accused should move away from the adversarial system once those things have been established, and then start working towards the insanity plea. So with this discussion, I hope that we have been able to cover all facets of the insanity plea, and we'll do a short recap of what all we had covered. We started with a history of where the insanity plea had to clearly begun. We spoke about the wild beast test, the insane delusion test, after which we spoke about the M. Nathan's rule. We spoke about the Durham rule. We spoke about the model penal code and how those changes have come around the world. And then we went back to our own Indian legislation, where we realized that it is still the same, and it is based on certain benchmarks, which is that if the person doesn't understand nature, or if the act is contrary to law or is wrong, then in only those scenarios can the person be protected under Section 84, and it has to be proved that such action is committed at that time that person is of unsound mind, as provided under 84. But also, if you remember, when we had this discussion, we also saw cases where how you behave before and after the incident is also taken into consideration, and that was in this Bhosale case, where I told you that the after killing the wife, he kept sitting there, and before also the crime was committed, there was a lot of medical history that he had. So before and after the incident is taken into consideration, but of course the section is clear that you have to see how or what is his mental setup at the time of commission of the offense. Then we went into a discussion of what are the types of persons of unsound mind. Then we had a discussion of Raman Raghav, where we understood that the person could be medically insane, but legal insanity requires you to understand or not understand nature, or contrary to law, or that it is wrong. And because he could understand those things, even though he was medically insane, he did not get the plea of insanity under 84. In SK Nair, we saw that if a person commits a crime when he is in a lucid interval, meaning where he is behaving normally, reasonably, logically, then in that scenario, he should not be given the protection of 84, even if before or after there could be situations where he was having some kind of mental depravity. We looked into some MCQs, and we ended with this latest case law of Prakash N, wherein the burden of proof principle established in Thakkar case was also discussed. But also what was added to it was that the fact that the court and the prosecution and the accused must come together, and also that the accused must establish reasonable doubt, right? If reasonable doubt is established, then in that context, the protection of insanity could come to such an individual if the court and the prosecution and accused also work together towards that discharge. With this, I think I would like to end this lecture. If there are any questions, there are any doubts, I'd be happy to answer these questions. Please post them in the comment box. In the next lecture, I will be dealing with again an important topic, which is of private defense. And that also has multiple questions coming in your papers. So I hope to see you all there. Thank you so much.